Warren.
Hey, good morning. Glad everybody made it. One piece. Thanks for your time yesterday also on the trails issue. So I'm here wearing other hats today, and I want to talk to you about the other pieces of the bill, and I've tried to divide these into sort of the buckets of issues that you've been talking about. So the primary clients I'm here on behalf of, one is Pomerleau Real Estate. Ernie was a advisor to the Act 250 commission process, and I think was probably the only developer that was part of that. Was on that, not on the commission, but an advisor or what have you. And I think I've heard him say number of times that he probably holds more Act 250 permits than anybody in the state. And he does primarily commercial real estate development. I also work with a number of manufacturers like Cabot, for example, who have been routinely involved in the Act 250 permitting process.
Cabot Agrimark or Cabot Hosiery?
Cabot Agrimark. I've done a lot of regulatory work for them over the years. And we haven't talked about this, I do represent the utilities. I represent Velco and Green Mountain Power and Vermont Electric Co-op. I also represent a company called Nextera, which does some large-scale solar development. And you might wonder why I'm going to talk about utilities, and I think some of you realize that the Section 248 process, where utility projects are reviewed, incorporate by reference in statute some of the Act 250 criteria. So when we talk about, in particular, when we talk about the habitat, forest blocks, and connectivity habitat, whatever you decide here, I think will play out or be imported into that process. So I'll try and let you know if a particular point I'm making is on behalf of a particular client and make that connection for you. The other thing, and I think you know this, I've worn multiple hats. I was at the Agency of Natural Resources and was a general counsel, so I'm pretty familiar with Act 250 permitting. I used to do some of that litigation for the state. And obviously now I'm on the other side of helping clients navigate the process. I'd say my primary job is to keep them out of court and out of litigation, which I've been pretty successful at. So just to give you that sort of background and context. So part of this is also trying to just give you my thoughts, not only on behalf of some of the clients, but just as a practitioner. I've been sitting here listening as much as I can. I haven't obviously been in the committee room all the time, but I've been trying to pay very close attention to the issues you are grappling with and some of the decisions you're trying to make. So I want to give you some of my thoughts and insight on it and try and see if it helps you make decisions one way or the other. I'm going to put off the discussion about the board structure and things to the end, and I'll try and go through the other pieces because I feel like there's been less focus on some of the other working pieces of the bill. And I'll try and make my way through those relatively quickly. Some of them are small pieces, some of them are larger pieces. On the road rule, there's one. I'm not going to opine whether I think going back and putting that in place is a good or a bad idea. I do think that it could be more specific in terms of trying to identify what it is you're trying to do or protect with the road rule. We've sort of talked about it, but I don't think the statute describes what are the things that we're trying to do by reinstituting that. The one thing I would, two things. One is there's a question, I don't know if it's been answered while I was out of the room. Maybe Ellen has an answer or somebody else. As you go along in figuring out how the road rule gets applied, let's say you get 5 or 6 years down the line, and that last part of adding onto a road or driveways or what have you then triggers sort of the 10-year aggregation or look back. Is it, and this is an honest question, is it that last part that gets reviewed through Act 250, or do you retroactively say we're going to look now at the whole piece? And I say that because going back, the same issue sort of comes up with around trails, quite frankly, is how do you retroactively go back and put a project through an Act 250 process, and some of that earlier projects and components may have been on the ground for quite a bit of time. That's just mechanically, it's an extremely awkward thing. I think it's something you need to think about as you consider this. And I don't know what the right now the bill has a 10-year look back, but if you think about someone who maybe it's you and you've bought into a small development or sort of an early part of a subdivision, and then 5-6 years down the road, Jane and Joe build their house at the end of that subdivision, and that somehow triggers Act 250 jurisdiction. Does that pull your house and the earlier components of that in, and what does that mean, and how would you know, and what do you do with that? So just there's so I don't know the history. I didn't try and go back to decipher the history of the road rule and why it went away. My guess is because mechanically it was very cumbersome at times to figure out some of these issues. But I think
yeah, I have a question about that. So, oh dear, I just lost my question. Maybe Jim has his, and I'll get mine back.
Currently, if a developer develops and stays under the just under the radar for Act 250 with the various number of lots.
Sure.
But then develops within we'll say within a 5-year or 5-mile radius of there, and
it's that last one that triggers it. That's my understanding. It wouldn't come back in and then say, look, we're going to go over to these towns where you've developed previously and look at those. That's
right. So this looks to me to be quite similar to that.
It could be, but it could be, and I guess that's the question here. You're talking about one sort of road or something that comes in, where there you're probably talking about projects that are potentially spread out. But I just think it's something you need to think about and operationally how that's going to work, and how people know what that means to them if their part of a project is now going to be pulled in some years later.
Well, for me and for the record of intent going into the years, it would not draw in all those others. It would be the specific addition, which is also, as you point out, the same for trails. I would hate to see 300 miles of trail suddenly get drawn in because of one connector.
And that's something we're trying to clarify.
Yeah, no, and I would say the same thing for that one. But
the other,
so I have a question for you. One of the things that this kind of brings up for me is master planning, and we have a proposal of an incentive through fee reduction for master planning. Like, do you think that's going to help people do that, and then?
I haven't focused on whether, I heard the discussion about the fee piece. I'm not a good judge of whether that's going to be enough of an incentive for somebody to do more advanced planning in order to have the benefit of that piece. There's certainly a strong logic to wanting to do that, so everybody knows what the expectation is, and you're not caught in that weird place later. But I don't know if that financial incentive is significant enough for a developer. I hadn't sort of done the math to see if that's really a strong carrot there. The other piece on the road rule, and I did talk with. Good morning.
So my question is in regards to a similar case, take stormwater management.
Yeah.
So now we have this 3-acre
Yeah, I'm going to touch on that later.
permit, and that looks at accumulation of 3 acres. So in some cases, such as in the town of the brave little hamlet of Williston, you have the town municipality managing the road, and yet these part of the subdivision all privately owned. So in aggregate, it becomes might trigger the 3-acre stormwater permit.
Yep.
And part of that was the outcome of having developments kind of sprawl in their development pattern and having no stormwater controls, and over time had degraded, in this case in Williston, Muddy Brook and Allenbrook. So So I think that there was an interest to try to look at it more
More holistically.
holistically.
Yeah.
And so getting to follow up on Representative Sheldon's comment, the chair's comment, what additional incentives should be in place to help? Because you said you weren't sure if it was strong enough. I'm curious to know if you have an opinion or some recommendations as really how to improve that incentive. Because obviously it's in everyone's interest. It provides clarity, it removes uncertainty, and yet at the same time it helps to achieve the objectives, which is to minimize fragmentation and while at the same time balancing that with.
Yeah. I don't, and I hate coming. I don't like to come with problems and not coming to you with answers. And this is not one I have a additional thought on, but I'm certainly willing to think about it. And because I agree, it doesn't do anybody, it doesn't do the developer any good, or people that have been in the project process on the early side, and then have this trigger sort of looming there. It doesn't necessarily lead to good decisions, but the reality is people that are building projects don't always have the time horizon or the financial horizon to know what they're going to be able to do, and a lot of it happens as those resources come available.
Right, and I use Williston for example because sometimes the developer has already developed the subdivision.
Right.
They're out of the picture.
Right, and that's a problem too.
And now you have the homeowner associations left holding the bag, so to
Yep.
speak, the proverbial bag,
Yep.
to deal with the fact that they have no stormwater controls.
Yep.
And similarly, we want to be thoughtful about how to ensure that we can achieve these goals while provide that predictability that I think everyone would benefit from.
I do agree with you. The one, and I can come with language, but I did sort of talk with the agency and with others about this. I don't think the road rule is intended to get at utility corridors and access roads, but if you've been, I know Representative LaFave knows the road system up under the Vetco lines up in the Northeast Kingdom. There are things that I think we would all call roads that the utilities use to access and maintain their utility corridors, and I don't think this is trying to get at limiting that or changing that. So I may have some very simple language that adds to the forestry, agriculture, for purposes of utilities accessing rights of way, something just to make that to make that clear. That should be something that would be I think pretty simple language to add. You heard from Jeff Nelson yesterday about ridgelines, so I'm gonna skip that topic. I will flag for you that you may hear very soon from some of the specific number of the trail organizations like the Green Mountain Club, Long Trail, Vermont Huts, on the language in here with regard to elevation. Obviously, a lot of their work and projects occur up in those higher elevations. Again, I don't think you were probably thinking about them in this context, but they may come to you and ask for clarification on how that would or would not apply to them.
So Warren, I appreciate that you're gonna pass over ridgelines, so is it fair to say, I wasn't here yesterday morning, so if I go back to Jeff Nelson's testimony,
Yeah.
that you agree with that, what he said?
Yeah, and I would say I also do work with the Vermont Ski Areas Association, so that's why Jeff is taking the lead on that piece. Something small, but I don't want to get lost. This was a recommendation from Mr. Pomerleau. This had to do with municipal deadlines. There's language in there. I think it says 90 days. It basically says if somebody's trying to seek an approval from a municipality to show impact on municipal resources or school or what have you, right now there's currently no time frame for those folks to get back to you. So we wanted to put something in there that, because, and I know Ernie said this to you last year, which is often it's not the Act 250 process that is the hard part, it is getting all of the different permits and approvals to then step into the Act 250 process and demonstrate that you have a complete application. We're not necessarily wed to 90 days, we just wanted to create some, and I've served on a DRB before, so I know that municipal bodies, they're meeting maybe every 30 days. So it's trying to get something on the agenda and get them to act isn't something that we expect to happen overnight. We were looking for a reasonable amount of time that we thought municipalities and other entities could accommodate that request, and not trying to be overly aggressive in what that number is, but at the same time, try and create some time frame so that some of these deadlines don't go on for 6 months or a year, or in some cases just an extremely long amount of time that I think we'd all agree is too long. So that's the context of why that's in there.
So we did hear from the League of Cities and Towns on this.
Yep.
And that some towns aren't really capable, and that in addition, that the default is, in this draft proposal, is an assumption that they won't have a negative impact, and that may not actually be accurate. So I'd be curious to hear if there's another, I mean, I think the suggestion from the League was to have the district commission, I guess, and depending on how we land there, have to pursue it. Like, yeah, to make the decision, and so I guess I put that out there for thoughts.
I guess I wonder how a district commission, if the municipality is the one that's gonna opine about whether this is gonna be a burden on their fire services capability or the school, how a district commission would be in a better position to get that information. If the municipality in a reasonable amount of time can't offer an opinion about that, it's surprising for me to hear that Karen would support the idea that we're going to pass this responsibility onto the municipality and they should look into it. That's usually not.
It was because some of the smaller towns just don't have the ability.
So I guess I would have to talk to Karen and say, what do they do now? I mean, does that mean it just stays open and it never comes to, closure?
Yeah.
I mean, how does a developer or anybody seeking a permit ultimately put something affirmative on the table if they can't get that body to act? There has to be some default to say you've had that opportunity. I mean, the applicant still could say, even if they haven't had that approval, I don't think we're going to have an impact on schools because we're talking about something that's going to maybe it's not a housing project. It's the kind of project that's not going to have 20 more families that are there. So I mean, I think there's ways for a developer to say, this is what I believe the impact will or won't be.
Right, which I assume they do now.
They do, but ultimately it's that letter
Yeah.
or approval. So.
And just to follow up, Karen Horn had also suggested 120 days.
Fine. I mean, honestly, it's not about trying to squeeze the town and make them make a decision faster. It's just saying, please make a decision.
Some known amount of time.
Yeah, some known amount of time. Right now, there's nothing. Originally, I think we were talking about 60, and I said, I've served on a DRB, and that's probably too tight.
We also heard that it may make sense to approach the school district for school services and the municipality for the municipal employees.
That may be true. I don't know if I would assume that's how it happens now, but maybe
Just
maybe
to
it's
clarify.
not. Oh, in terms of the actual language, to make it clear that there are different courses of approval that are sought. Understood. Okay.
Okay.
I'm gonna keep trucking here. The climate change criteria. This is the one. This is the one that basically talks about siting your building, and the language in there says. Give me 1 second to find it real quick.
Orientation.
Yeah, it's the orientation language. Here it is, 33. No, that's not it. I'm not going to waste time trying to find the exact language. I know you know exactly what I'm referring to. The language in there is awfully vague. And it basically says you've got to orient your building and sort of design your building to account for changes in climate, precipitation, storm events, as of the time when you file your application. That's really vague. If really what you're talking about is how you site and orient the building, that's one thing. But saying, Representative Hill, that you're going to build a house and you need to take this into account, whose information are you looking towards to decide what precipitation events are going to look like in 5 or 10 years? I mean, the language really needs to be tightened up in order for somebody to know what they're being asked to do. Right now, you go to Roger Hill and ask him 10 years from now, what are the rain patterns supposed to look like? And it needs, I think I understand the intent from talking with other folks, but it really needs to be tightened up. Otherwise, no one's going to know what to do with it.
Is there something you would reference?
I think there's just language in there that it could probably be trimmed. It could probably be trimmed back. What I heard from some of the other folks is we want to take advantage of things like, the ability to use passive solar when you orient your house. I mean, some things that we all think about if you're designing, or you, at least now living in Vermont for 20 years, I didn't appreciate that growing up in Florida, how important it is to orient your house in a certain direction to maximize sun. So I think the language could be tightened up greatly rather than have somebody say, you got to do this based on future weather predictions. It's just too loose for I think for people to know what you're asking them to do. Another one, and I think you're gonna have testimony on it later today, the capability and development plan piece. The joint proposal pushes that to a study. I feel like the planning portion of the bill right now is sort of the unknown piece, at least in my mind, or it's the piece that's probably least understood. I feel like it's sort of the sleeper issue. And the draft that I saw from you says that you basically would use those maps as part, they would come into sort of the permitting process. I honestly don't think that anyone knows what those plans and maps are. I think asking them to go adopt maps right now seems awfully premature. So I would ask you to take a look at the joint language, because these are concepts that I think have the potential to have some very real value, but also real impacts. And I just don't think it's ready to say, go develop these maps, and these really should play a significant role in the permitting process at this point in time. I just don't think anyone knows what we're talking about. I don't. So let me turn my attention real quick to the forest block connectivity piece, because that's and the burden of proof shift. That's probably one of the pieces, and then I'll finish with the board structure piece. So I know we worked together on H233 a couple of years ago, particularly with the chair on this. So I know where some of the language in your bill is coming from. This is still, the idea of forest blocks and connecting habitat and fragmentation is still very much, I think, an evolving area. And I don't mean evolving and trying to discount the issue at all. What I mean is that it's not as well known and understood as a wintering deer yard or bear scarred beach area, or an area for a bat hibernaculum. This is an area, and this is based on my experience working on several renewable energy projects, working on telecommunication projects, and working on having these issues come up. It is not something that I think A&R can easily draw a box around, and it is a constantly evolving topic. To that end, I think the sweet spot on this issue lies somewhere between the proposal you got from I'll call it the joint proposal, I think you've been referring to it, and your proposal, which gets into some level of detail about avoidance and minimization. I think this needs it needs more work. There needs to be a robust rulemaking process around defining. Again, this sort of goes back to the climate change piece. You've got to tell people what the expectation is of them. Right now, there's and I think you heard this from Liam. There's terms in there like patches of habitat or contiguous areas of forest. How big an area of contiguous? How big is a patch of habitat? how big is a contiguous area of forest when you're saying you're in a forest block. You've got to provide some level of predictability for somebody going into the process. And right now, the language in there is very vague. That doesn't mean you have to spend your time defining each and every piece, but I think there's a rulemaking section at the end of the joint proposal that needs to have more direction to the agencies as to what they actually need to develop it through the course of rulemaking. I didn't want to come and offer you language today until I realized there might be, if there's an interest in that, because you've been bouncing around between various language on these, on this. I'm certainly happy to do that. Your language also has a definition of fragmentation, which, as an example, I think is really important, because ultimately that is what you're trying to, that's the issue you're trying to get at. The joint proposal doesn't have that in there. I've talked to people that offer the joint proposal. I think they agree that needs to be more, that needs to be contained in there, but that's an example of trying to provide more definition around this.
Jim?
Two things,
Yeah.
Warren. Three things.
Yeah.
One, your advice is always well considered and appreciated. Second, I wanna be clear on forest blocks and connective habitat and connectivity are, you believe, are very important
Yeah.
going into the future.
Yeah.
Okay, and secondly, the tightening down of the rulemaking process in this may very well be, in my mind, also an important part of it. And thank you for the offer, but please don't offer us any language. Take it to the Senate. This train is leaving the station.
Understood. So, just a couple of things on that. One is just and I think you talked about this when we were working on H-233. Right now, an applicant, this also goes to the burden of proof issue. Right now, an applicant has a pretty good idea, not down to the most precise level of where Bear Scarp Beach area may be or a Deer Yard area may be. That's something that they or a consultant can easily wrap their head around. I don't think there's that amount of certainty with regard to forest block or connectivity habitat. I don't want to cite examples in current cases, but I can tell you I've been involved in a recent case where there's an issue where the agency is saying that area is going to be important in the future for habitat, for wildlife connectivity. And there is no way in the world that somebody could have known that going into the process and designing the project. There's absolutely, I think, no way for them to know that. So whether it's an obligation for the agency to start doing more in terms of mapping and being able to get that information out to people. So again, so a less sophisticated developer has an idea before they spend their time looking at an area. There's some certainty there, or at least a flag for them to know. And I think that's really important. And you heard from John Austin, who probably is, I think, one of the most respected people in the state, certainly on wildlife issues. I worked with John for a long time. You need to have the mitigation option in there. You will be missing opportunities if you don't have that in there, because in some cases, and maybe you haven't heard this, if mitigation is not there and a person can't build a project, there's a lot of other types of projects and things that could be built in that area that are never going to trigger Act 250, they're never going to trigger 248, and that area is going to be changed in a way that is going to be worse, potentially, in terms of habitat and wildlife. So having mitigation as an option provides you and the state sometimes with opportunities to do a lot more than you otherwise could, than just saying, don't build that project, because your mitigation's off the table, you weren't able to sufficiently minimize the impact, therefore you're done. That doesn't mean somebody could come in and build a couple of houses or something like that that's sub-jurisdictional, and have a far greater impact and a worse outcome. So I would suggest you absolutely have to put that concept back in there. Just tying this into the burden of proof on these criteria, on the wildlife criteria and this habitat blocking connectivity, you have shifted the burden of proof to an applicant, rather than leaving that with the Agency of Natural Resources. Last year, the Agency of Natural Resources, I hope they would say the same thing today, they would say, we are the experts. We're the ones that are seeing how this evolves, and we're the ones that are sort of stewarding that science. To shift the burden of proof to an applicant on these issues, you haven't provided the tools for an applicant to know what the rules of the road are. Maybe it could be done during the rulemaking process, but I think you're making a mistake by shifting that burden of proof to applicants on that criteria, particularly because this is an area that's evolving. They are not going to know. Most unsophisticated applicants are not going to know where to go for the information. If the information is going to be there, I would submit it's not all necessarily there. A&R is the expert. If I have heard that one of the reasons for shifting the burden is because sometimes if the burden is on the person who's maybe concerned about the project, that they are unable to get access to the property to see if there's a rare, threatened, endangered species. If access is the issue, fix the access issue. My position is, if somebody's asking for a permit, that you have an obligation to allow people onto your property under reasonable circumstances to do their due diligence. If that's really the issue, I think that's part of what comes along for applying for a permit. So if that's the issue, that's one that you can easily solve. I don't think shifting the burden is fair, given where we are.
And McCullough, Dolan, and McCullough,
Okay.
I guess. You got other witnesses
Yep.
teed up too.
Yeah, I'm thinking primarily that the shifting of burden of proof actually changes this burden from, let's just say, a neighbor with no pockets at all to do the investigation to rebut the project, and versus the developer who has a business plan and the financial ability. Now, we don't want to just go to that cookie jar, and say it's endless, but by comparison, a developer that's paying a significant amount of money for property and then putting, as we all know, significant amounts of money into the proposal and then ultimately the project would arguably have a lot deeper pockets than a neighbor who's concerned. And so I'm a little surprised that you're actually saying that this, what you are, because I hadn't conceived that was a problem for the Agency of Natural Resources. I don't know if you can explain that part briefly. We do have to move on, but there's going to be the PUC thing part too. So.
Yep. So it's really about access to information when you're shifting the burden. I don't think the neighbor who may not like the project or the developer are in an ideal position if the information is not accessible to either one of them. The issue is that the Agency of Natural Resources is the expert. They look at all the Act 250 permits. If they think there's an issue, they're the ones I think that need to be sort of the primary ones to help identify and raise it to a district commission or whatever the proper forum is. That's what I'm saying. I'm not trying to disadvantage one or the other. And the PUC, I'll try and be quick. The PUC connection here is again, if somebody's widening a transmission line corridor, or someone's building a renewable energy project, the way I've been able to give my clients some comfort on the forest block and a connectivity issue and the fragmentation issue is that we will have a robust rulemaking process so that we won't have sort of a moving goalpost. You will have a very good idea going into it what the expectation is if you are in one of these areas, because right now that has not been the case. It has been a sort of an amorphous process that costs time, it costs money, it creates uncertainty for everybody. And it's just not a good way for people to move through the process or for the agency to move through the process. So that needs to be, and I don't think this is in your version. It was in H233. These criteria should not become effective until that rulemaking is done.
It was in H233?
I think it was. I think there
Rulemaking?
was something that said, you have to go do rulemaking on this, and these criteria don't become operative until that rulemaking is done.
So I think we're hearing you on this, and
Okay.
I may differ with my colleague and ask that if you do have language, I would
Okay.
really welcome it.
Okay, okay. So I won't talk anymore about burden of proof.
I have a question.
Representative Dolan.
My question is about if A&R becomes the experts, are they allowed to go back that time, because that would be above and beyond their current job responsibilities in managing A&R permits and processes?
It's a good question for Lewis, Commissioner Porter.
They're
To
constantly struggling
I
with-
mean, to date, he hasn't been a fan of Bill Back because it's a fairly cumbersome process, and I respect the fact that they're doing work that they're not getting compensated for.
Right, and we
So-
heard that they might even, because of limited resources, they might even have to pull back out of Act 250, and that would be, how can we ask them to be more responsible and leader when
No,
they
I-
can't afford?
I think we need to figure out how to make sure they're getting the resources they need to do this review. I don't disagree with that. I wouldn't ask them to do something without the resources.
Thank
That's
you.
the issue we're trying to struggle with on trails as well, is how do we stand up a project? We can't ask them to do something without those resources.
Thank you for your time.
Yeah.
I have a quick question, Warren.
Yes.
Doesn't this change a little bit on both proposals, both the committees and the joints, in terms of, we're talking now of doing like a 30-day scoping where the applicant would come to the, either the town or even, I imagine, the state agencies involved and say, this is what I've got in mind. Would, at that time, Department of Wildlife or someone start to chip in and say, wait a minute, there's a bear habitat or there's a rare endangered species out there?
Maybe. I had an experience on a project where at the PUC where you have to give 45 days notice, and the applicant did that. And we got some comments from the department, and we changed the project. And then we actually filed the application, and there was a whole set of new issues that were raised. So I can't say that, I understand what you're saying, that if there's an opportunity there,
Yeah.
but in some cases, an agency or department that's stretched thin isn't gonna always take a look at a project until it's real and to them it's been filed. But that does bring me to your, it's a good segue to get into the last piece here, which is, I don't know if all developers will agree with this, but I am a big fan of doing a lot of work on the front end to save time on the back end. I think you heard Annette Smith refer to work we've done with her on Cabot and Agrimark permits in the past. So you do have this 30-day notice process in there. I think that's a good start. I think there are certainly people that I work with that will do more than 30 days, not being directed to, because it saves a lot of time and potential litigation on the back end. So there's potential to do more there. Again, I don't know how. I've heard varying opinions about whether this 30-day notice is sort of fluff and window dressing, or and really doesn't provide the opportunity to involve sort of the local community, because that's to me when that would occur. And this will get into sort of the joint proposal model. I do think the joint proposal model is the right model, and I'll explain why. But I think if you're going to do that, this becomes very, very important. That pre-application process becomes important, and making sure that that is accessible, that people actually do sit down and take a look at that. Take a look at that project early and try and figure out what issues they can address and narrow down. So getting back to the the bigger issue you've been struggling with. I was surprised when I read the 103 pages the other night to see that you had taken sort of two concepts that, depending on where you sit, were unpopular and putting them both in the bill, meaning beefing up the district commission process and going back to the so-called verb. I can say that I favor the process, the joint process that was put in front of you, and I'll tell you why. I think it was pretty telling when you heard from Jocelyn Wilczek, who's a younger attorney here in Montpelier, who's very experienced at the PUC and is serving on a district commission. I think what you heard her say was she's the most experienced one on her district commission, and there's high turnover on the district commissions. And maybe that wasn't always the case, but it sounds like it's very challenging to find people who want to serve on the district commissions. It's not a trivial undertaking. I served on a DRB for 6 or 8 years. It takes a lot of time, and that's talking about people putting a porch on the back of their house as opposed to a substantial project. So you've got that fundamental, I think, challenge with if you try and formalize the district commissions, you've got a real problem with finding people that are gonna wanna put the time into and have the ability to serve in a way that you can really formalize that process and put that additional responsibility on them. And you're gonna have to staff those district commissions with attorneys. That's gonna be expensive. So and what's interesting is probably 5 or 6 years ago, maybe longer ago, or definitely, I'm sure I was in front of this committee at some point and saying, make district commission processes on the record. I'm positive I've said that in the past. I don't think that's as good an idea, and the reason I like the joint proposal is, to me, that was a new concept. Others have said, oh, this has been an old idea. Honestly, that was not an idea that I had ever heard presented before. And the reason it makes sense is that I think you're trying to do the same thing. You're trying to create a process where you do it once and you do it right. If Mr. Pomerleau were sitting here, he would say, kill me once, but don't kill me twice. You know, let's do it, let's invest the time and put whatever process in place to do it once and do it right and give people access to the process. And if we need to beef that up by having the regional members be voting members, or if we need to beef up the pre-application process in some ways, or make applicants able to avail themselves to do more if they want to do more up front, but do it once and do it right. The way you've got it now with the district commissions, you are trying to do that. You are trying to create a robust process and do it once right. I just don't think that's the right place to do it. I just don't think it's going to work because of some of the limitations of what you have in terms of staffing those district commissions and beefing it up and giving them the legal resources and other things to do it right. I just don't think I think it makes more sense to try and focus on one entity and do it right there. I mean, I think that's really it in a nutshell when I'm sort of looking at those two choices.
So I would like to hear your comments on I have concerns that the joint proposal approach, it does, I don't disagree with your take on doing it right, doing it once, where to do it. I have concerns about capacity.
At the district commissions
No,
or at the...
in the joint proposal, having one board roving around the state addressing major applications. That's one of my concerns with it, and the other is, we're trying, I think we have agreement in this building that regional economic development is a shared goal.
Yep.
And centralizing, when we would anticipate that other areas of the state besides Chittenden County might experience more major applications if we're successful with regional economic development initiatives.
Mm-hmm.
And I just wonder, is that really the right direction to go when that's our goal? And I realize your major person, at least the first person on the list of who you're representing, is in Chittenden County.
He's actually all over the place.
So-
Virgins, more than that area. But
Not
I
in
had,
Bennington County or Rutland County, and I mean, I think, anyway.
I think, but
my
anyway,
point is
I hadn't
regional.
heard that concern yet, so I'm hearing it for the first time, and I hadn't been in the room the whole time.
Well,
But
that's
that
great.
makes sense.
I plant that seed.
Yep.
We do have witnesses who we're now over we're almost a half an hour behind, so
Okay.
I gotta wrap it up.
Okay.
With you.
Okay.
Okay.
Go ahead.
this is a more general question. You
Yep.
referred to the PUC a number of times.
Yep.
There is not concern, there's angst that the joint proposal, the direction, that everything other than perhaps the status quo is creating a PUC type environment, the court-like type environment that will be intimidating to citizens, will be expensive, more expensive actually, to developers and more expensive to citizens who want to be parties and need to be parties to have a complete view. You've presented, you've been to the PUC, you've practiced likely on both sides of that there. And could you respond to that concern?
I think the idea of formalizing the district commission process should raise, and I think you've heard from folks, raises the same exact concern.
Well, I'm thinking actually with the enhanced NRB or a
Sure.
part of that. That's the part I'm at now in my mind.
Well, like I said, I think you could do more to try and, I think you could try and focus to do more on whether it's the 30-day notice upfront process and making sure that process provides that early opportunity for people to get in and for the project applicant to hear them and try and make accommodations and try and make changes to projects. I personally, that's the way I try and work with clients.
Yeah,
Maybe
yeah,
others
yeah,
don't
yeah.
think that's a great idea because it adds additional time. Making sure that those regional reps have a voting role to bring that local flavor to that process. I think there are ways to try and make that process as accessible as possible. But I think the counter proposal of formalizing the district commissions raises the same exact angst. I've
Yeah, it
heard
does.
it. I read Annette's testimony.
Yeah.
And the fact of the matter is, any substantial type of project, it gets formalized by the very nature and sort of sophistication of the project. So I think we all have that same goal of doing it once and doing it right, and we're just trying to figure out, do we do it in a number of places, or do we try and do it in one place? If I was trying to distill it down.
Hearing officer, can you say up or down on that idea?
It works on a lot of the smaller cases that I've been involved with at the PUC. Things that are just not going to be as hotly contested, where the issues are fairly simple and straightforward.
Yep.
So I think there's a role for it.
Thank you.
Okay.
Thank you.
I have other things, but I'll save them because I know we're behind. And thank you for giving me additional
Can you
time.
send them to us?
Yes.
That would be awesome. Thank you, Warren.
Thanks a lot.